Okay guys, now let's start the class. Okay, so we continue with our second part of the first unit, which is legal theory. First is the distinction. We've already done this. Okay, you know these civil law versus common law systems. The real difference is the importance of judicial precedent, which is very high in the common law countries. Concentrate on the class, guys. Raghav, concentrate. Harsha, come and sit on the first. Come and sit next to Muskan. Come here. Okay, so the importance of common law systems like what you have in India is the importance of judicial precedent, which I think we've discussed briefly. Judicial precedent means precedent is obviously that it comes from before, right? It comes from the word precede. Okay, so therefore precedent. And one thing I would suggest from a pronunciation point of view is that you can just get used to, because there's sometimes people pronounce this as precedent, which is not wrong on its own, but then you get confused as in President of India, President of the United States. So what I would recommend is a good rule where this word is pronounced as precedent, so that you also get the connection to the idea of precedes. Okay, and the President US or President of India, that you can say precedent. So that would be precedent and this would be precedent. Okay, so that helps you to stay on track. And so judicial precedent is basically a preceding judicial decision, which is of a special type. That is a type which has a particular type of preceding judicial decision which has particular influence on the current case. It will affect the way the current case is going to be decided, and it will determine the outcome. So that's what is meant by judicial precedent. Generally will determine the outcome. So that's what we mean. We'll understand this. So this is very important in common law systems, which we already said is a mixed system, because in common law systems we follow both codified law and judicial precedent. A pure common law system would only follow judicial precedent. This is how the English law developed in the olden days, because there was no codified law. There was no parliament in England because there was a king, and the king basically set up roaming circuits of judges who would go around the country and decide disputes based on the customs and traditions of the common people. So that's why the word common law, and also the idea of one common law for the whole of England. So that's where it came from. At that time there was no codified law. Codified law means all these acts that you see, Contract Act, Transfer of Property Act, all the acts that you see here. These are all the acts. Now these would all be called codified law, because these are codes enacted by Parliament, which is a similar system that you see everywhere in the common law countries and also in the civil law countries. Okay, so where are we? We have to go here. All right. Okay. So so we have both codified law and judicial precedent. Both are important. We'll see how they apply prospectively, retrospectively. That also we discussed. Okay. Remember, there's a long discussion yesterday at the end of the class. The couple of questions asked by Mehul and Monira. There's a lot of lies in the background. So those are also part of your syllabus. Okay. Anything that is explained to them is also you are expected to know at the end of the video. Yes.
Sir, they are codified because they have sections.
Not really, because they're sections. They're codified in the sense they are written into a code. That's the main idea. Because in the early days of the common law system, nothing was even written down. It was just, there was a knowledge that this particular case was decided. It's only after a few years that it started to get written down, the decisions of the judges. And even then, what is written down is actually just the judgment. There is no principle that is being written down as such. Whereas in these codes, if you look at any of these codes, if you look at this, say for instance, Transfer of Property Act, which is again, these are all British laws. So if you see here, you'll see the common law of England on transfer of property. You can see how old this act is. There have been some amendments, but by and large it's the same. Okay, so it has all these sections, but it's codified in the sense that it's written into a code. Like in the early days, you had the code of Hammurabi and all that. So it's a written down set of rules. Whereas in judicial decisions, you're just noting down the decision. You're not explicitly noting down a rule. Okay, so that's why it's codified. So it's a code. So all right, so this is what you have here. So we've already discussed this stuff. Now, hierarchy of courts, I've told you to see the presentation in detail if you want to. All right, here. And then but generally we just understand, everybody knows the Supreme Court, High Courts and District Courts, this kind of hierarchy. So, and this is also optional for you. Anything optional will be in italics. So one new word so the next module which we have is to understand this doctrine of judicial precedent, very important, which is the word that you need to understand understand or remember is stare decisis. This is pronounced as stare decisis, which is a part of a longer Latin phrase. You don't need to memorize all this stuff. But the basic idea here is, again, you don't have to memorize the words, but to get the idea, that is all we need. We want you to just conceptually understand the idea. The stare decisis really means that if something has been decided, don't disturb it. Okay, don't disturb things that have already been decided. This is the idea. So the main idea here is that if you have a similar case, when we look at this article that we will be reading, the article by Glanville Williams, we can actually refer to that now. Maybe we can make it a little smaller here. Is this still readable on the last bench? Can you still read the fonts? Okay. So here, if you look at this article is in your notes. You are required to read this article. I'll help you along with the reading for most of the article. I've also highlighted some important parts. This is kind of like a little bit of spoon feeding because we don't have that much time. But ideally, what you should be doing is you should develop the skill of trying to understand how to highlight the important parts. When you're reading something, how to highlight the important parts. Okay, Yukti, don't talk. Come and sit next to Saloni here. Let's split you up from your buddy. Who's your buddy? Kritika? Okay. Come and sit here. Okay. Talking is very distracting. I don't want to be distracted by anybody talking. If you're bored, you can sleep. That's all. Okay. So what is the meaning of the doctrine of precedent? Here, this is the same thing as what we are calling the doctrine of judicial precedent. Okay. So a habit of following their previous decisions. Okay. That we'll come to ratio residendi later. So the idea is that if it's a similar case, if you have a similar case, like there's a drunk driving case where somebody is driving drunk and he runs over a pedestrian and the pedestrian dies. Okay, so that's a similar case. This kind of case can happen once again later on. In this case, so the idea is that the previous case, however the previous case was decided, the next case should also be decided in the same way. The idea here obviously is, if we go back to our notes here, we see that this is basically the idea. So a previously decided case, don't disturb the principle laid down in that case. So the value of this, once again, you can connect it to the principles that we studied with when we were studying formalism, when I was telling you why I prefer formalism, or why some other people prefer consistency, right? So the consistency point, you can see here that if we follow this rule of stare decisis, that which has already been decided before, if a matter has already been decided before, if a similar matter comes up later, then you should decide it in the same way, right? So you can see clearly that it will lead to consistency. It is likely to foster consistency in judicial decision making. And can you also see the connection between consistency and certainty? That those who are subject to the law, like if I'm subject to the law, if I know that okay, up to 5 milligrams of alcohol in my blood is not considered to be a punishable offense if I'm driving with 5 milligrams of alcohol, then in that case I have that certainty, so I can act accordingly. Okay, and if I know the rule, so I need to know the rule from before, so this gives you certainty. So the people who are subject to the law, they will have certainty in the way they can conduct the way they conduct their lives. This is clear. So consistency of decision making leads to certainty, and certainty is a very important factor. And when you understand, because everything derives from all the greatness of a country derives eventually from economic prosperity. Without economic prosperity, it's hard to maintain greatness, right? Like you have countries like North Korea and all, which have been, of course, partly funded by China. So they have a lot of military strength and they have some weapons and all that, but it's not really a very strong foundation, because their economy is a disaster, right? So at the end of the day, if you really want to be so you see the enduring strength of the US, part of that reason is because their economy is very strong. Okay, the biggest economy in the world, very prosperous, and now you can see that they're adding more and more to their military budget, partly because the economy is also going well, so they can afford to do that. Okay, so certainty therefore business, a good business environment is important, and this is something else you need to understand as a business student, that certainty is very important for business. Even if you're not going to take finance, you should understand this principle, that businesses require certainty in the regulatory environment. This is a very important factor in fostering what we call, have you heard this expression, animal spirits? In macroeconomics, have you heard animal spirits? Animal spirits is just basically, it's a kind of like inspiration. It's something like inspiration, or I can just write this down. You should write down this. This is actually you've heard of Keynes? since you're business students, I'm just going in a little bit into it. Okay, animal spirits is actually something that you really can't put your finger on, but this is just like confidence, okay, confidence and inspiration, these kind of things. So animal spirits is a term that was coined by the English economist Keynes. You might have heard of Keynes, John Maynard Keynes. Okay, so Keynes coined this idea of animal spirits. What he's basically saying is something very intangible. It's not like industrial production or total capital stock or total number of occupied houses. You can't put your finger on it, but it is something intangible like business confidence. Okay, do businessmen feel confident about making investments? Because everything is uncertain, so you're going to take risk anyway. Do people feel comfortable taking risk? Okay, so this is the idea of animal spirits. Very important for business students to understand and be exposed to it. So what the connection is that the regulatory environment, the legal environment, if it fosters certainty, okay, it is very good for business. It increases business confidence, and it generally fosters animal spirit. So if you monitor this transition from the Obama economy to the Trump economy, one dramatic difference between Obama and Trump is that Obama, because he was a slightly leftist leaning president, so he was over-regulating the economy, putting a lot of regulations. You can't do this, can't do that, can't water your farm with this and that water, you have to protect this fish and that fish. So all kinds of regulations. So what happened was that had a very dampening effect on business confidence. Businesses were not sure what kind of regulation was coming down next. Whereas when Trump came in, so there's a dramatic difference between Obama and Trump on the point of regulatory the approach to regulation. Whereas Trump's approach, he already told people before that he was going to attack regulation like a maniac. So he said for every regulation, and what they have actually done in their administration so far is, for every new regulation, they have cut 7 old regulations. Okay, so and if you remove the regulatory burden on businesses, it automatically increases business confidence. There's a lesson for this in our country also, because our country also has the same problem that we over-regulate everything. Okay, that's why business activity is a little bit, it dampens the spirit. So this is something which most governments don't seem to understand, whether they're Congress or BJP. The mindset is the same. They over-regulate. So this is the idea, which is with a little bit of a departure from the law as such, but this is a very important idea. And since we found that you don't know important words like this, animal spirits is basically business confidence, and so certainty is very good for business. Okay, so that's why, and since Trump has clearly promised that I'm going to drastically keep on cutting regulations. Now he's cutting infrastructure regulations. They used to take about 12 years to get a permit to build a highway in the US. Bridge or a highway. He has cut that down to 2 years. Now he wants to cut it down to 1 year later on. And you see how aggressive he is in terms of cutting regulation. Now this will obviously have a huge impact on investment, because the capital which was not willing to come in for a 12-year period of regulatory approval, when it's a 2 year or 1 year, that capital will come in. So it'll have a huge impact on investment. So this is what is meant by certainty. So you can see the connection between the legal framework and the impact on the economy. After all, at the end of the day, the economy is everything. If you don't have a strong, vibrant economy, eventually you have nothing. So this is the idea that stare decisis helps to foster consistency and certainty. That is very good for business. So under stare decisis, we will be studying few other concepts. First, we start with vertical versus horizontal. Okay, very simple stuff. You need to refer back to the hierarchy of courts for this idea. You remember the hierarchy? Supreme Court, High Courts, District Courts. So whenever a higher court is binding a lower court, remember what stare decisis says, that if there is already a previous decision on the same topic, on the same controversy that you're deciding right now, if there's a previous decision, then you should follow that previous decision. In whichever way the previous decision was laid down or decided, you should follow that same rule and decide it in exactly the same way, so that you have predictability and consistency of decision making. Is this clear? All right. Okay. So yeah.
So lower court and higher court does not be the same?
No, yeah, it will be the same, but the reason it is the same, okay, quiet please guys, quiet. So the reason it is the same is because the lower court is bound to act according to the decision of the higher court. As you can see here, we already have a principle we have an article in our constitution, which is Article 141. Which is, it says here that the law declared by the Supreme Court is binding on all courts. All right. So what does this mean? Since the Supreme Court is at the apex of the pyramid, the Supreme Court, that all the high courts in this country are bound by the decisions of the Supreme Court. So whenever Supreme Court has decided something, the high courts have to follow that particular decision on a similar matter. Okay, that's what it means. So your point is correct, but the more important point is to also understand why that ends up being the case. The reason it becomes the case is because the lower court is bound to follow the decision of the higher court. Okay, so the stare decisis principle only says that you should follow previous decisions, and when we talk about vertical stare decisis, we are talking, I'm just coming to you, we're talking about vertical stare decisis. What we are saying is that this particular the subsequent decision is the same as the previous decision because a lower court is being bound by a higher court, like a high court has been bound by a Supreme Court, by the Supreme Court, or a district court is being bound by the high court decision under which, so if a Madras district court under the Madras High Court is bound by a Madras High Court decision, okay, in that case we still have vertical stare decisis. So you can see the connection to the hierarchy of courts. Okay, one type of stare decisis is vertical. Yes, Krish, what is the question?
So if law gets amended, then how lower court will follow whom?
No, if the law is amended, then generally the court will try to follow the amended law, or if they feel there is some confusion between the Supreme Court higher court decision and the amendment of the law. So generally they are supposed to follow, in the case of a conflict between, in our common law jurisdiction also, because it's a constitutional democracy, right? So you have parliament in that sense is supreme, so it should the codified law should have precedence. But if there is any confusion, they should refer it to a higher court or a higher bench or a larger bench within the same court. But generally they are expected to follow the codified law. So if the law is amended, then you follow the law rather than the precedent. Okay, so if there's a conflict between the two, you follow the codified law. Okay, so vertical stare decisis, now everybody understands these are just terms. Yeah. Okay, quiet. Yeah. Yeah. There is a change. Yeah. No, Telangana is we are coming to that. Just wait for a while. You will get your answer. Okay. So, okay, quiet please there on that row, Mahima and all. Don't talk. What is you have a question about the topic? Then you ask me. Don't ask Vipul. You ask me. If you have a question, you ask me. Okay. I'm not penalizing anybody for asking questions. Have I penalized anyone for asking a question? So you ask me. Okay. So that way we avoid all these multiple soundtracks in the class because it's very disturbing for me. I don't want to hear any multiple soundtracks. Okay, all right. So we are coming to Monira's question. Will get answered. Her question is whether Telangana is affected by Madras High Court decisions. Okay, first understand horizontal stare decisis, opposite of vertical, where it's a power of a court to bind itself. So because we place such a high value on consistency, what we are saying is even the Delhi High Court is bound by its own decisions. All right. So in general, if the number of judges on the bench is the same, which we call a coordinate bench, or higher. Okay, so if you have a 3-judge bench on the Delhi High Court following and they are faced with the decision of either a 3-judge bench or a larger number of judges of the same High Court, they are required to follow that. Even if it's a smaller bench, still the default rule is they should try to follow the previous decision. Okay, even if it's a single judge decision of the Delhi High Court that is being given to that is being presented before a 3-judge bench trying a new case, all right, which is supposed to be similar, even then the default rule is try to follow the previous decision. Don't try to disturb. Remember, stare decisis, don't disturb what has already been decided. So that is a preeminent rule. But if you feel that the previous decision is wrong, then you can change it. Okay, it's not that you can never change it. If you feel that a previous decision is wrong and you are actually a larger bench, okay, and a single judge decision is felt to be wrong by a 3-judge bench, they can change it. Okay, yeah.
Decision get challenged.
No, that's not really challenged in the sense. See, if it's a 3-judge bench coming later after a single judge bench decision, and they feel that the single judge decision is wrong, then they can change it themselves. Okay, but they should always try first to adhere to the previous decision, unless it's wrong, in which case they can change it. And if it's a challenge, if it's like a coordinate bench, like a 3-judge bench is facing a decision by a previous 3-judge bench, as happened once in the Supreme Court on a very important arbitration case. So Supreme Court 3-judge bench was facing a new decision on a similar point, but the later 3-judge bench of the Supreme Court was faced with a previous decision by the Supreme Court, also by 3 judges. But the later judges felt that the previous decision was wrong. So then they referred it to the Chief Justice for convening a larger bench. Because it's 3 versus 3, so the Chief Justice would convene a larger bench to decide this controversy. Okay, so that in that way it gets handled. Okay, so these are very clear now. These points are very simple, connected to the hierarchy of courts. These are just, we are combining this vertical and the doctrine of stare decisis with the hierarchy of courts. You can read this detail for yourself. I'm not going to go through everything. If you have a question, you can ask me that. Okay, then we have other couple of points which are coming to the point that Monera raised. There's a concept of a binding precedent versus a persuasive precedent. Okay, so binding precedent can be of 2 types. Okay, where you either have, so a binding precedent is basically one where the later court is bound to follow the decision. Okay, the precedent is the decision. We refer to decisions as precedents, or judgments or decisions or cases as precedents, and they the later court is bound to follow that. He's bound to follow the precedent, so that's why it's a binding precedent. So it can either be a combination. It can be in a case of binding precedent and vertical stare decisis, where you have a situation where the High Court is bound by a decision of the Supreme Court. In this case, it is both a case of binding precedent and a case of vertical stare decisis. Are you following? We're just combining the 2 concepts we studied. Is this clear? If a high court is, let's say, bound, we are combining the 2 actually. So we should put it here. We can combine it this way. Okay, I'm just writing broken English here, so that we don't waste too much time writing. When High Court bound by SC, this equals binding precedent So first I discuss what is a binding precedent. Any precedent by which any court is bound is a binding precedent for that court. Now we are trying to just make it a little more complicated and combine it with the previous concept that you studied. So it is a binding precedent and it is a case of vertical stare decisis, because both are in play here, because the High Court is being bound by the Supreme Court. So therefore we say that it is a case of binding precedent and vertical stare decisis. Now it's clear, Mahima? Okay, is this clear? Raghav, concentrate on the class. Okay, so this is one. Okay, the other is where we have when, let's say, when High Court bound by its own decisions. That will be what? Yeah, so that will be binding precedent plus horizontal precedent. Okay, so for instance, if you have a clear-cut case of a binding precedent by let's say own decision. Okay, so own decision, if we want to make it very clear that it's binding, we can say own decision where there is a decision where the current bench is a 3-judge bench and they are, let's say in the Calcutta High Court, and they are being presented with a precedent which is also a Calcutta High Court decision by a 7-judge bench, in which case the 3-judge bench of the Calcutta High Court is bound by the 7-judge bench decision of the Calcutta High Court. So in this case we say it's a binding precedent, but it is what kind of decision, stare decisis? Horizontal, right? So we will copy horizontal from here and we'll make this actually we'll try to make this
This system has been implemented in most governments.
Yeah, the only difference is in the civil law jurisdictions, like say Germany, Italy, and all that. The importance of judicial precedent is not that much. They do try to follow case laws, which they have started as a new. I mean, it's a new trend. But in general, the rule in civil law countries is the judge is not so bound by the previous decisions. The judge is really bound by the language of the code, the statute. Okay, like in France, you have the Code of Napoleon, which is Napoleon Bonaparte created this code. Okay, so this is basically it. Okay, so these are clear now. We have combined the two concepts. All right, what happened? Lots of talking going on in the class, very disturbing. Okay, from the next class I will be deducting marks, whoever I see. Okay, I don't have to hang everybody who has committed murder, as long as the people I'm hanging have all committed murder. Okay, so I don't have to see everybody who is talking. Okay, so the rule is very. So the next class I'll have the rule set up, because in this class I didn't punish the other class also. But you should get into this habit. So now you know. By now I think you understand that I don't tolerate any talking in the class. There should be no sound at all. If you have any question, you have to ask me. All right. If you have any problem, you want to take a water bottle or something, you raise your hand. It's just like an exam. Okay. All right. So this is the idea. Now you understand both this. No, we have to answer Monira's question. So because we only started with a binding precedent. Okay, we followed binding precedent, and then we have combined it with vertical and horizontal stare decisis. That's clear. But we still haven't addressed persuasive precedent. Now what she's talking about is, let's say what happens if you are arguing a case in the Hyderabad High Court, and you cite before that court, you cite a decision on a similar matter by, let's say, the Madras High Court. Okay, so in this case the Hyderabad High Court is not bound because they are on the same level. Okay, so they are not bound by the Madras High Court decision or a Delhi High Court or Calcutta High Court decision. In this case it is called a persuasive precedent. In this case, the Madras High Court decision that you are citing before, let's say Hyderabad High Court or Calcutta High Court, some other high court, that would be called a persuasive precedent. That particular case you're citing, it is only a persuasive precedent. It is not binding. Persuasive is in contrast to binding. Okay, so persuasive means it is still open to the court in Telangana to be or the court in Hyderabad to be persuaded by the logic of the Madras High Court decision, but they are not bound to follow it. Okay, so it doesn't mean that they will never follow it. If they are sufficiently impressed by the logic, they may still decide to follow the same decision. Yeah, but they are not bound to. Yeah. Yes, Krish.
It has been seen that if a lower court give a decision in a particular case, then higher court is bound to give the decision according to the lower court, and Supreme Court is bound to give the decision according to the higher court.
No. What is this? You are saying this. Are you asking me whether is this what I'm telling you, or you're telling? No. It's you're giving the reverse view. Actually, we are saying it operates from top to bottom. Yeah.
In a particular case, if a case gets started from a session court,
yeah,
and go appeal Supreme Court,
yeah,
then it has been seen that the higher court gives decision according to the session court, and Supreme Court gives decision according to the higher court.
Yeah.
That will it be called as a precedent or?
No, it's not a precedent. In that case, what is happening is that what Bhavesh was mentioning the word challenge earlier. In this case, what happens is when the session court of session gives a verdict in a criminal case, then the person who loses in that verdict, that person may challenge the decision of the sessions court before the High Court. Okay, and then the High Court can, what the example you're giving is that the High Court agrees with the Sessions Court, and the High Court says, okay, we agree with that decision, which means they affirm the decision. That is said to be affirm the decision. Okay, they affirm the Session Court decision. Then if you are able to get a certificate on appeal, or you get a special leave petition, you go to the Supreme Court on appeal, they hear your case. The Supreme Court may also decide to affirm the decision of the High Court and the Sessions Court, and that may happen in a particular case, or they may decide to overrule. Okay, so in this case there are multiple challenges to a decision at each level. As you can see here, the Supreme Court also, in the case of these Nirbhaya convicts, they lost once in the main decision, but then they filed something called a curative petition. You have a curative petition where you can try, even after one petition in the Supreme Court has failed, you try for a curative petition, which they judges here in chambers, and they may still decide to allow that petition and overturn, which is what happened in that case. If you remember this famous fire in that, what's that area called, that in Delhi there was a very famous fire. I don't remember. A lot of people died. There was a theater. There was a fire in a theater. I'm forgetting the name of the theater. But anyway, there was a fire in a theater. And a lot of people died. And then the Supreme Court actually, in a curative petition, they allowed those people. They didn't put them in jail. The owners of the theater were not put in jail. Right? So I forget the name of the case. So that happened in a curative petition, even though they lost in the Supreme Court in the main hearing. Alright, is this clear so far? You understand now what we are talking about? Persuasive precedent also is clear now? Okay. Now this is a question which is raised in the Glanville-Williams article also. You have to read this article. So the question that arises automatically is that if we are telling you that in the system of judicial precedence, stare decisis, in that case the previous judgment has to be followed, but as you will see very soon, judgments are very long. Okay, so which part of the judgment has to be followed? So here's the answer. The answer is that it is only the ratio decidendi has to be followed, not the obiter dictum. Okay, so we are teaching you two of these words. These are the singulars, ratio decidendi and obiter dictum. Okay, so the ratio decidendi will explain that, and the plural is this. Okay, this is the plural, dicta. Again, too much talking going on here. What is happening? Who's talking? Ashita, who is talking? Some noise. I can hear a female voice somewhere in the background. Okay, all right, let's go to this. Okay, so doctrine of precedent, they've already explained this. Okay, here, this is what he's explaining. What is the ratio decidendi? This is the part of the case that possesses authority, okay, which means that this is the part of the case. So we are going to find out how to extract the ratio decidendi of the case, and many of the assignments that you will have in your CP assignments in the class, very common question is going to be, what is the ratio of this case, right? So we'll find out what the ratio decidendi, if you split it up, loosely translated, it is the reason for deciding or the logic for deciding. So in ratio decidendi, you have to understand, this is where your English comprehension will be tested, where you have to understand, you have to read the judgment and you have to figure out what is the logic that the court has used to come up with the decision. Okay, to come up with the decision that it came to, what is the logic that it used? Okay, so that's reason for deciding. And it is the ratio decidendi of a case that is actually the binding precedent. When we say it's binding on the lower courts, on the subsequent courts, what is binding is only the ratio decidendi of the case, and things which are not the part of the ratio decidendi we will refer to as obiter. Okay, obiter dicta if there are more than one. So anything that is not part of the ratio decidendi would be considered obiter. Okay, not essential to the decision of the case. Other statements that they make. Okay, so let's go and try to understand this article a little bit. So this is very important. As you will understand, you will find that the course may seem a little bit difficult because it will be done in the flipped classroom style. Right now I am explaining stuff to you. I'm kind of spoon feeding you. Later on, when you start getting into your CP assignments, you will be given a judgment and I won't explain anything. You will have to read the judgment on your own, and I'll give you questions. You'll have to answer those questions and you'll be graded on your answers, and after that I'll explain it to you. So it's much more intensive than normal learning. Okay, but it definitely is beneficial. Most of the batches initially they get a little bit nervous, but later on they find that they actually like it. So we are going to try that. So you have to develop the skill, and the reason it's being taught like this is because I believe that instead of teaching business law in a very light form, we have to teach it in a very high intensity form, so that you're actually trained to be able to take on even lawyers in argument, because the training of lawyers in India is quite there's a lot of variation in quality. You don't know what you're going to get if you actually, God forbid, have to fight litigation on your own. Okay, so this is basically the thing. We've already discussed this. You know this paragraph. You can understand what it means. All right. So we're going to try and figure out how to understand the ratio decidendi of a case. It's basically here. I've just added. So whenever I added stuff like this, plus logic of how one leads to the other, right? Because he has defined it as material facts of the case plus the decision thereon. But actually I've just added, just to make it very clear, that is, it's plus the logic of how the material facts lead to the decision of the case. Understanding that logic, okay? So he's given you an example here. If facts B and C are material in a case, and then you have a conclusion X, if you have any other case in the future where facts B and C exist as material facts, okay, or where you have A, B and C, what he has not mentioned is, here to be clear he should mention that if you have A, B and C, then A is immaterial, just like in the previous case. Only B and C are material. A may be present but it's not material. Okay, in that case we'll understand what is a material fact. So in that case the decision also has to be X. It's the same way of what we have already discussed, okay, with adding new concepts like material facts. Okay, now we'll see what this means essentially. But then if you have a future case where you have A, B, C and D is also material, then you can no longer say that the same conclusion X has to come out as the conclusion, because now you have an additional material fact which is D. Yeah, so the situation the outcome may change, because now you have, earlier you had only B and C as material facts in the previous case. So in the new case you have B, C and D also as a material fact. So now you can no longer say that X must be the conclusion. Okay, it could be some other conclusion because of the additional material fact. That's basically it. So question is, what facts are legally material? You can also use the word salient, legally salient. Yeah. So we'll understand, maybe once we understand material facts, it will become a little bit clearer. So the idea is material facts plus the decision on the case, material facts of the case plus the decision of the case. Okay, and as I said here, just to make it very clear, plus the logic of how the material facts leads to the decisions. Okay, analysis of the material facts leading to the decision. What is the logic that takes you from here to there? That is also, I mean, part of the ratio decidendi. So okay, so what we are saying is, material facts, if you have a case where there are the same material facts, right, then if you have a subsequent case where the material facts are being repeated and no additional material facts are present, then the decision has to be the same. Okay, I think once you understand what material facts are, then it will become a little clearer. Okay, so once you see here, so you can hear, you guys are familiar with this term called salient?
Yes, sir.
Salient features of the discussion, okay, prominent features or important features, critical features, okay, which characterize the discussion. So that's what is really meant. You can also use the expression legally salient. All right, so now in this case, what you say, he's talking about a situation where you have somebody being run down. Okay, in this case, the fact that the plaintiff is the one who brings the action. Okay, so if somebody runs me down and breaks my leg, I will sue that person for damages, and then I will be the plaintiff and he will be the defendant in a civil case. Okay, I'll give you these breakdowns as part of your notes later on, but essentially that I'll be the plaintiff is the one who brings the action in a civil case, and the defendant is the person against whom it is brought. So the fact that the plaintiff had red hair and freckles and the name was Smith, these are not material in a legal from a legal perspective. What matters is you have a human being who is being run down by a car. So whether the person's name is Smith or Jane or whatever it is not material. Whether they were wearing a blue shirt or they had red hair, these are not material. Okay, so but they are obviously part of the facts of the case, but they are not material. So this is how you understand. So here you would say the only thing that is material is that you have a human being who was crossing the street and is getting run down. Okay, so that's how you try to understand material facts. All right, and then when you have the same material facts, it should lead to the same decision. So here what he's saying is that what is material in this kind of a situation? Somebody does this driving negligently, and in consequence he injures the plaintiff. Like in Delhi you have the famous BMW driving case, right, which has been going on for many years. That in consequence he injures the plaintiff. So negligent driving is a material fact. Okay, what color shirt the defendant was wearing, that is also not relevant. Okay, but the defendant is driving negligently, that is what is relevant, and in consequence he injures the plaintiff, that is also irrelevant. And then through negligent driving, so then you have a general principle that comes out of a decision like this, that if you drive negligently and you injure some person, then you will be liable under the law to pay damages, right? This is generally right. So now you get some idea of what is meant by material facts, all right? Those which have legal significance or legal salience. Okay, so now they're looking at a particular case, Wilkinson v. Downton. Okay, this is an old case, as you can see, but as you will see, they actually refer to even older cases, and as you read the judgment. So now from here onwards, we are going into the judgment proper. So when they write like this, right J means right justice. Okay, so it's Justice Wright who is writing the opinion in this case. So now you're reading the opinion in Wilkinson v. Downton. This is the case. Okay, 1897, you can see this. So these are the times when there was no codified law in England. This is Queen's Bench, the QB is Queen's Bench. So you have a Queen's Bench which is like a court, like a High Court or Supreme Court. So you had a Queen's Bench decision on this matter, and there's no codified law, so the judge will evolve certain principles and give the decision, right? So what happens in this case is that you can read the facts here. So essentially a guy goes and scares, he wants to scare a woman and basically enjoy seeing her getting scared. So he tells her that your husband is has been in a car accident and he's lying somewhere. Please go and fetch him. Okay, so naturally the woman, after hearing this, she goes into a nervous shock, like she's in a panic, she has a panic attack, and she has this, what we call in the law, the expression here is nervous shock. Okay, where her nervous system is affected, and it is also obviously has physical symptoms, and so she's hospitalized, medical treatment and all that. So then she eventually, what she does is she sues the defendant. Okay, so in this case the plaintiff is Wilkinson and defendant is Downton. So this is how cases are written. Okay, when you look at the first court of first instance, where you first bring the action, the way we write it, this is Mrs. Wilkinson is the lady who is affected, and Downton is the guy who played the prank. Okay, so the cases are always written like this, that the plaintiff's name is first and Downton's name is second. Okay, but later on, if Downton goes on appeal to a higher court, if Downton loses in the lower court and he goes on appeal to the higher court, then it will be written as Downton versus Wilkinson. So in any court, whoever's name appears first is the person who brought that action to that court. Okay, and you have to also see what level is that court. Is it a court of first appeal or second appeal or whatever? Okay, so you can see all this. So the two questions in this case is that they have claimed for two types of damages or compensation on two grounds. One is that, so we'll handle the smaller matter first and we'll see how that is decided, and you can see the application of judicial precedents. So the smaller matter they have claimed is a small amount. Okay, I think 1 shilling something, because she sent a couple of people by train to go and fetch her husband. So the rail fare for those two people, she's claiming that also, right? And so that part, what the judge is saying is, that part is very easy to decide, because there's a previous case called Pasley versus Freeman, in which this particular type of question was already decided. So now you can see the application of judicial precedent. Can you see that?
Yes, sir.
That instead of having to reinvent the wheel in this particular case to decide this question of the railway fares, what this judge is saying is, well, we already have a similar issue decided, and you can see how old Pasley versus Freeman is, nearly 100 years before this case, right? So this common law in England started from the days of, actually it started almost, you've heard of William the Conqueror, 1066 AD, the Norman conquest of England. Okay, so William the Conqueror came in 1066. So this stuff already started within William the Conqueror and Henry II, which is the next third king after that. So this was already in place pretty much by the early 12th century AD. This system was already there, that you had a system of judges going around the country, all over England, deciding cases, and their decisions were being sort of recorded as the common law decisions, and that's how the common law formed. Okay, so you can see how the 1798 is already many years into the start of the system. And many of these principles that you see in our laws also, contract, everything is written by the British. Contract Act, Sale of Goods Act, pretty much everything. These are all the codification of the common law principles evolved over hundreds of years in England. Okay, all that the British did was in India, they took those very same principles from the common law and they wrote it into a code like the Contract Act or the Sale of Goods Act or Transfer of Property Act. So that's what happened. So here what is happening is very old decision. They see this and they straight away apply the precedent of Pasley versus Freeman because it deals with the same question of this kind of compensation for railway fares in a similar situation. So can you see one example of the advantage of this judicial of using a system like stare decisis that doesn't lead to faster decision making or slower? Faster, right? Because you don't have to reinvent the wheel when the same issue has already been decided previously. All you have to do is pull up that precedent and you can just apply it straight away. You don't have to go through the rigmarole of going through the logic once again, right? Yeah.
But sir, it will increase the burden of High Court.
In what way? In what way? No talking, guys. When one person, I can't hear clearly what he's saying. You have to maintain silence in the class. You should understand this principle. You have to maintain silence. There should be no multiple soundtracks coming through. Yes.
Sir, if the decision was taken according to the stare decisis, then it may be challenged further.
How? You can always challenge it. You can always challenge it. But the point is that what we are trying to illustrate here is that this in Wilkinson versus Downton, one particular question arises that is this lady entitled to compensation for the railway fares? This question arises as one of the questions. So what the judge is doing is he's applying this doctrine of stare decisis by taking a previous decision, a previous judgment, Pasley versus Freeman, in which the same issue had come up. And there the judges had decided that yes, in this case you should get the compensation for the transport cost. Okay, so what he's saying, since this matter has already been decided before, I don't need to go through the logic once again. I will just see that the Pasley versus Freeman, the issue was the same that we are deciding now of transport costs in this kind of a situation. So then I have to decide it in the same way. I'm just going to apply that rule from Pasley versus Freeman and decide the matter. Right? You can always challenge this, but in this case, if you can show that the circumstances were the same in Pasley versus Freeman and in Wilkinson versus Downton, then in that case, you're not likely to succeed in the challenge because the stare decisis principle is being applied in the right way because the circumstances are the same and they have taken a previously decided case and applied the ruling in that case to this particular case, which is how it should be done. So if you want to challenge it, you have to show that the circumstances were not the same. So the precedent was wrongly applied. Are you following the logic? That is the only way you can challenge it. Yes.
Just one more thing.
Yeah.
Person may hire a lawyer to defend the case.
What happens? Another lot of talking going on still. Should not see any. What is the problem, Muskan? Who's talking? You're talking. No talking. I can hear a female voice in the background still murmuring. Yes.
If a person is hired a lawyer to defend the case, and the lawyer must know that it maybe judge will take the decision on the basis of stare decisis.
Yeah.
Then he may present it more in a different way or in the same way.
Yeah, so I think if I understand you correctly, what you're saying is that the lawyer who's arguing your case today, he should be able to, or he will find some similar cases which have gone before, dealing with similar facts, and he will try to cite those cases in your case as well, in the arguments for your case. Is that what you're saying?
In a different way.
No, if it's different, then you don't cite it. Right? Then you don't have an advantage in citing it. You have to find cases which are the same, which are talking about similar circumstances. See, if you're arguing a case, let's say for medical malpractice, like what happened to our famous bowler B.S. Chandrasekhar, he was put in a wheelchair because of medical malpractice, right? So he's now in a wheelchair because the doctor didn't do the job properly. He did not take proper care in performing the operation, right? So if he's suing for damages, then he can't cite a previous decision on a bank robbery because the bank robbery and medical malpractice, the circumstances are not the same, right? So you have to take, so his lawyer would have to take previous decisions on questions of medical malpractice or medical negligence. This is an important area of the law actually. So there's well developed principles on, many cases have been heard on these matters, medical negligence. So he has to find cases on medical negligence which are very similar to the facts of say Chandrasekhar's case. And then he has to cite those in the court while he's arguing, and then hopefully the judges will agree and then they will decide accordingly. Of course, he has to also pick cases which would be favorable for his client. Actually, legal ethics requires the lawyer to submit both types of cases, those which are favorable and those which are not, okay, on the same issue. But generally lawyers don't bother, they only submit cases which are favorable for their client, not which are those which are against, okay. But this is an important point, so this is one, I'm just coming. This is one of the reasons why I'm telling you to learn this, study the law in an intensive fashion, even if it's only one course, because many times you'll find that lawyers are not even aware of the right precedents. Okay, so therefore you have to be aware that, okay, you have to know how to search for precedents. You should know that the right precedent, you should understand what is the right precedent. You should be able to read. Yes, Jafar, what is the question? Is your question answered properly? Okay, yes.
Suppose we have a new case and it involves case types of 2 or 3 different cases.
Okay, again noises are coming. Yes.
So, sir, what will be the possible solution? The possible solution should include the solution of all the previous cases, or it would be a new thing?
No.
Like, there is a case, like there has been a case, someone ABCD has the previous case types, and the new case which we are attending and involves ABCD as well and EFG of another case. And what sort of decisions will be taken based upon 2 different cases happened before and same?
No. If your current case includes A, B, C, D, E, F, G as material facts,
Yes, sir.
then just taking a case with A, B, C, D doesn't help you.
Yes, sir. So,
You have to take a case with A, B, C, D, E, F, G.
yes, sir. So,
You have to find a case which has that. Unless those particular issues are so clearly separate that you can use one set of precedents for one issue, as you can see here.
will they-
One particular issue is being decided by Pasley versus Freeman, but they will see that the second issue is not being decided by Pasley versus Freeman. So you can do that also. Depends on what kind of issues are actually involved.
So what my concern was, will the victim will suffer double penalty? Like ABCD has a jail imprisonment.
No, there will be no double penalty. I can already anticipate your question here, because there is no double penalty, because they are separate issues. In this case, you can see there are 2 claims. If you are following this case, in this case there are 2 claims. One is the claim for the pain and suffering, okay, and the medical expenses. Okay, those are connected claims. One claim, that is one claim, and the second claim, which is much smaller, which is for railway fares. So there are 2 separate issues here in this case, and the judge is able to separate them out, and he's therefore using, for the second one, he's using Pasley versus Freeman as a precedent, okay, because it matches this clearly. And in the next, for the main issue, if you see, they're also citing Pasley versus Freeman, that lawyer for Wilkinson, but the judge doesn't agree on that larger issue, on the larger claim. The judge doesn't agree that on the first claim of medical expenses and pain and suffering. Judge says that Pasley versus Freeman is not the right precedent for this particular issue. So it depends on the facts of the case. If you can separate out the issues, that is fine. But in general, if you can't separate out the issues, you have to find a case which has the same material facts. Okay? Yeah? Alright. Okay, so let's try and continue to understand this. That here what is happening is, as you can see, so this they have quickly decided. So you see one advantage of the doctrine of precedent, that cases can be decided very quickly, or at least certain issues in the case can be decided very quickly. The second part, he comes to the major claim, which is for illness and suffering. Here the lawyers suggest these 2 precedents, Pasley versus Freeman and this versus this, saying these are damages caused by fraud. But the judge says, no, this is not matching the facts of this case. These are not, the judge says that in this particular case, what she suffered, illness and suffering, it cannot be said to be due to fraud or deceit. Okay, he's saying he's taking a different view on it. So therefore, these two will not apply for the first claim of the medical damages, of the suffering and the medical costs. So he's going to have to decide this according to some other principles. Okay, so he's going about doing that. Okay, so what he's saying is the general principle that should apply over here is what I've highlighted over here, that Downton willfully did this. Okay, Downton willfully did this. He did something which was calculated to cause harm to Wilkinson, right? And in fact, he therefore injured her right to personal safety and thereby caused physical harm. And that is basically the principle. As you notice here, for instance, we'll see this later when we talk about substantive laws. Generally, in a legal decision, what is happening? You two in the corner, I think you guys are talking now. Don't talk while this whatever I'm explaining. Okay, so what he's trying to do is he's trying to evolve a general principle according to which he's going to decide the main issue, which is the damages claim for suffering and medical expenses. Okay, so what he's saying is this guy intended to cause harm and cause physical harm, and therefore, see, every person has a legal right to personal safety, so he violated a right. So this particular kind of thinking you should get used to, that in the law you generally have a claim only when one of your rights is violated. Okay, so later on when we see things like substantive laws versus procedural laws, substantive laws, what they do is they give you certain rights. Okay, so you have marriage laws, or you have contract law, or property law. Everywhere the law is giving you certain rights and also imposing certain liabilities. So when your rights are violated, you can claim for damages. That's basically how the system works. That's why he's bringing in this idea that her right to safety was violated by the actions of the plaintiff, and in fact physical harm was caused to her. That would give a good cause of action. This is an important expression also to understand, cause of action. So generally, you understand the word infringement. You understand infringement? Infringement means any kind of trespass or trampling or any damaging, the sense of damaging. Okay, so we use infringement with respect to rights a lot. We say that your rights were infringed. Okay, so right now, so infringe her legal right. So you can see the connection. So in the law in general, if you are making a claim before a court for damages or restoration or something like that, you have to show that one of your rights, your legal right, was violated or infringed, and that only that gives you a what we call a cause of action. This is an expression that you should be familiar with, because in the law we use the expression. So if we say that, it's like if I say that I was walking by the street and Mehul came and made a face at me. Now there is no right to have there's no right that I have that nobody should make a face at me. So if he makes a face at me, that's not a violation of my right. So if I go to a court and say that I want to claim damages because he came and made a face at me, so the court will throw it out, because the court will say that there is no cause of action, because no right of yours was violated. Okay, so this is what we mean by cause of action, that you have to show that some right was violated. Otherwise, you do not have a cause of action before a court. Okay, this is the idea. So you should understand this also while studying this particular paragraph. Okay, so so he's further working on the derivation of the ratio decidendi. This part is important because you have to make sure that here, okay guys, what happened? Now Muskan, once again you're talking to her. This is what we have to avoid. From the next class onwards, I'm going to randomly deduct marks for people. Okay, so now you know what has to be done. No, not a single word should come out of anybody's mouth. It's not that difficult. Okay, I've also been a student, and I can sit in the class for 1.5 hours just paying attention to what the teacher says. Even when I feel the teacher is not teaching particularly well or something, I would sit there, just practice this discipline. It's not that difficult. Okay, so you just have to practice the discipline. You guys have got used to bad habits, talking in the class, because in others, normally in undergrad colleges, teachers are not that strict. I've seen situations where actually the teacher is teaching, people are sitting in the back and chatting, and there's a constant multiple soundtracks, and those who want to listen to the teacher, they also can't listen because with multiple soundtracks you get confused, but the teacher doesn't say anything. People are not strict. So people get used to all this kind of indiscipline. So here, this will not work. So you have to get used to being very, very strict. Otherwise, you sleep. Okay. So what he's saying is, he's trying to develop the ratio decidendi. They're trying to show you how it's developed. Okay. So here, what he's saying is, remember what the judge said earlier? Willfully did an act. The judge is trying to derive certain principles according to which he will give the decision. Okay, so he's saying that this guy Downton, he willfully did something. Now, how do we know that he actually willfully did? Because you can't read anybody's mind. You can't see what is in his mind. You can't see what the intention is. Okay. All right. So what he's saying is that what the guy did by telling somebody a lie like this, if you tell somebody that your husband is injured and legs are broken lying somewhere, obviously the lady is going to go into a panic and it will cause some kind of anxiety to her, and this may also have physical effects. She may become sick because of a panic attack. So therefore, any normal person, any reasonable person should have been able to foresee that if you say these kind of things to somebody, they may actually have these kinds of consequences. They may suffer these kind of consequences. So since the consequences of his actions were quite foreseeable to any reasonable person, therefore we have to assume that this guy, whatever he did it intentionally. Okay, so that's what the judge is basically saying, because earlier he says willfully, so now he's saying, okay, now how am I correct in saying that he did it willfully? So he's saying, yes, I was correct, because the consequences should have been pretty obvious to anybody. Therefore, if he did it, we can assume that he did it willfully. It's like if I take a gun and I pump 10 bullets into somebody's brain, and then I say that, oh, I did not intend to kill him. That is kind of stupid, because you don't really know. Of course, technically you don't know what my intention was, but any person should understand that if you pump 10 bullets, a person is going to die. So that means from the actions that I took, the consequences of my actions were should have been so obvious that we can conclude that it was my intention to kill him, right? So that's what the judge is saying here. All right. Yes. Yeah. What happened? Any question? Okay. What happened? Kamya is desperately looking at the clock. So from the next class we'll have an alarm so that you don't have to look at the clock. Okay. So intention to produce, you know this word imputed? Imputed means you ascribe the intention. Okay. We say it is intention to produce such an effect must be imputed or ascribed. We assume that he had this intention, so we are imputing the intention to him, although he has not explicitly declared it, or we don't have an explicit evidence of it, but we are imputing the intention. That means we are ascribing the intention to him based on his actions. Okay. Alright, okay. He is not citing an authority for this particular decision. He is just deciding there is no particular authority for the first part of the claim, which is the pain and suffering and the damages, the pain and suffering and the medical expenses. Because this is what we call a case of first impression. On this particular issue in 1897, there was no previous decision on the same issue. So this is what we call, when there is no decision on the same issue, we call this a case of first impression, which you can see here. He's also written it here. Okay. So there is of course the ancient thought of battery. Battery, you can understand, you can maybe learn a little bit about some of these terms. Battery, which is when you actually have to hit somebody. So these two words are used together, assault and battery. These are the ancient thoughts of assault and battery. Useful to know these. Assault is when if I threaten to hit somebody when the person actually feels that I'm actually going to hit him. So that is called assault, when you're threatening to cause battery. But when you actually hit somebody and physically hurt them, that is called battery. So these are old terms in the law, assault and battery. Okay. So he has just decided that this is not a case of assault or battery, because he did not actually physically hurt her directly. Okay, the physical harm she suffered was coming through the psychological damage that she suffered. So battery requires you to directly physically hurt somebody. Okay. Right. So now you see how you extract the ratio decidendi. okay, which is by finding the material facts. Okay, we'll try to go through some of the, you have to read this article yourself also. I'm not going to go through everything. Okay. Okay, I think what we do is we go through, you guys go through this article again on your own, all right? That now some of the things I want to just talk to you about, I'll try and highlight some of the points here, okay? Which is ratio density, you have to find the material facts, okay? You have the material facts. These are irrelevant, I'm not going to highlight that. Right. Defendant, okay, this is something else you need to know. The defendant, if he loses the case, he is said to be liable. Many times I've seen students using language like in the when they're deciding cases and then they're presenting on the cases. So you have to understand there is a right gives you an entitlement. What is the problem now, Garima? Who are you? What are you discussing? I mean, okay, rights lead to entitlements. Okay. Okay, and liabilities are quite obvious. Okay, so very often what people say, the use of the language, you have to be careful about the use of the language. Be quiet. When somebody has a right restored to her, in this particular case what happens is the judge determines that Mrs. Wilkinson's rights were violated. Are you following? She had a right to personal safety. Yes, Chinmay, this kind of behavior will lose you points. Okay, Bhavya is sleeping, don't disturb her. Okay, so no, if she's sleeping, there's no problem. You don't have to be embarrassed. Okay, we are just, I'm actually holding you out as a role model. It is better to be sleeping than to be talking. All right. So, so Bhavya has no liabilities. Only Garima and Chinmay have liabilities. Okay, so in this case, now rights give you entitlements. So the way we should use the language is that Mrs. Wilkinson's rights were violated. Her right to personal safety was violated by Downton. So therefore we would say that Mrs. Wilkinson is entitled to damages. Very often what people will typically say is when the court, and who has to pay the damages? The defendant, that is Downton. Okay, very often people use the language incorrectly by saying that Downton is entitled to pay damages. That is not how you should say it. Downton is liable to pay damages and Mrs. Wilkinson is entitled to the damages, entitled to receive. Are you following? Let's write this down clearly so that you are not making, now you understand rights and liabilities. So if everybody has a right to personal safety, then if I go and beat somebody up, then I am liable for violating their right to personal safety because I have infringed their right to personal safety. So in this case, I am liable for having infringed their right, and the person whose right has been infringed is entitled to claim damages, okay, or entitled to receive damages. So here we say rights lead to entitlement. So here we say that Wilkinson is entitled to damages because her rights were violated. Okay, she is entitled to damages. I can't see anything here. Since her rights were infringed. Okay, and Downton is liable to pay the damages, or we say he has a liability to pay damages. Okay, so in this case the spelling is wrong of Downton, but we ignore that. Downton is is the defendant. He is liable to pay damages. Okay, so that is the basic idea. So please make sure that now that I've explained this to you, nobody should make this mistake in the future, that the person whose rights are violated, he has an entitlement to receive damages, and the person who has violated the rights, he is held liable by the court and he has a liability to pay the damages. This is clear. The language should be very clear for the benefit of people getting restless. Okay. So we'll give you, because I've taken some. 1 minute. Before that, now let me give you instructions. Please make sure that, guys, because I need to move a little quickly. So please make sure that, because I want to get into the cases very quickly. So with one more session max, in the next session itself, I want to get into contract law. So please make sure you read the rest of the Glanville Williams article on your own. All right. And if you have any questions, we can ask you. And also you can ask me. And also let's read the rest of this Unit 1 notes also on your own. It's pretty clear. Okay. All right. So now you can. I've given you 24 seconds bonus. Okay.